little bit more.
I have put on your place, there is a course evaluation that we need for Greg. It is two-sided. If you will please be so kind as to fill that out, both sides, and you can leave it here. If you don't want to fill that out, that's fine. Andy and I will fill it out for you. Just kidding. All right. So far, so good, huh? All right. Moving along. The next section we are going to talk about are changes that they made June of last year. And we are going to talk about the closing attorney holding the earnest money. So I could go into a whole hour-long dissertation on this form, but I'm not going to.
Yeah, I can speed it up, and I can complain probably more quickly than she can.
Okay. So in your contracts handout, it's on page 21.
Does everyone here generally know what an ACH is? Automated Clearinghouse? Yes. Okay, well you might as well forget what that is. You don't even need to know because we don't accept those in Georgia. So, and every once in a while, you'll have somebody, one of your clients that may accidentally, or actually on purpose, send us an ACH of their proceeds, and please talk them out of that, or please remind them that that is not, absolutely not an acceptable way to send any type of funds to an attorney, be they earnest money or their proceeds, and it will tie up their funds by hours or possibly days as well. Most attorneys' IOLTA trust accounts are set up to reject the funds, but some of them may hold them before they send them back. The reason ACH funds are not acceptable is because they can be recalled by the sender, and so they're not technically good funds. So, I'm not even sure why a GAR contract would have this in there, given that, Georgia attorneys can't accept it. But it's what we got. So please just keep that out of your client's vernacular in terms of what can be accepted in the way of funds in Georgia. So that being said, here's the other little thing I want to talk about. We as the Georgia Bar did not ask to have this put into the contract, okay? So please don't be mad about the fact that wires were suddenly required for earnest money, because I can promise you no closing attorney asked for this. And this has been, if it's a thorn in your side, it's a thorn in our side as well, because we, at least me, and I'm sure all of my other friendly competitors are the same, get wires all the time into our account that don't have contracts with them, based on the goofy timing that is allowed on this. The wire can come in, but then the contract doesn't have to come until 2 or 3 days later. And we have to just sort of sit on this money that doesn't have a home yet. And that is problematic for us at times, because I don't like holding other people's money without having some responsibility for it. So the other problem we have, and I'm probably skipping around slightly, is we had people walk into our office with checks when you guys have clearly filled out an F10 and an F11, F510, F511, and I know we'll address that issue in a moment as well. That is problematic as well, and we'll address that. I know I'm jumping around. Now I'm getting to my rant. But let us not rant. Okay, so we've got the ACH issue. Jumping ahead here, all cash transactions. We reached a point where it's time to not put us down as the holder in an all cash transaction, because what's going to happen there is that we're going to be forced to interplead the funds. What's been taken away from us is the ability to exercise the 10-day letter. And I think Dana's explanation of how the 10-day letter procedure works was so wonderful that I don't think I even need to go into how that works. And I won't read this chapter and verse to you, but what this says in short form is I don't even get to base my dispersal on a reasonable interpretation, which would be typically another opportunity for dispersal. You know, in the absence of the 10-day letter option, the holder could just say, hey, I don't even have to send a 10-day letter. I've evaluated the facts, and I think the buyer should get the earnest money back. That's not even an option. The holder shall interplead the funds. So you would do well in the case of the all-cash transaction to let the holder be your broker, because in an all-cash transaction where the attorney represents a designated party, most often the buyer, it's presumed that the attorney is an interested party and is a bias toward the buyer, so they are just assuming that you can't get an impartial position there. Whereas I suppose they presume that a broker is going to have some impartiality. I don't know how that is.
Well, I think my understanding also of this interplead, especially if it's all cash, and I don't know why it would be different all cash versus a mortgage loan, but your closing attorneys, some of your closing attorneys also have additional parts of their practice where they will help with creation of an LLC or writing of a will or some other types of those things. So a closing attorney could have an additional ancillary relationship with potentially one of the parties, because if it's all cash, the closing attorney doesn't have to be approved by any certain lender. So the buyer and the seller can negotiate, well, if I'm one of the parties and I already have a business relationship with Andy's office for whatever reason, and I think it's all cash because it's not lender, because there's not that other overlay of the lender. My understanding is that's another reason why, again, for impartiality. So it costs money to interplead, and guess where those fees come from? Out of the earnest money.
Yeah, the court filing fees alone are at least $200 to $300 of the fund.
In an all-cash transaction, how do you determine which party you're representing based on who's paying the closing costs?
Well, the default language in the GAR says that the closing attorney represents the lender, except in all kinds of cash transactions that they represent the buyer. Now,
even if the seller's paying the closing?
Right.
You guys, your contracts are nothing more than a set of instructions. So some of the things that, especially if you're very well versed or very familiar with the GAR contract, it's not law. It's just per that contract. For example, in that specific question, Peggy asked, in an all-cash transaction, whom does the lender represent? Is it always the
attorney?
I'm sorry, who does the buyer represent? Is it always the buyer? Well, no. In the GAR contract, it's the buyer. For example, if you're writing a contract on the RE forms, that's a point of negotiation. In an all-cash transaction, it doesn't even use that word represent. It says buyer or seller shall choose the closing attorney. And in HUD contracts, new construction contracts, investor contracts, that might not even be addressed. So just because there's something that you are very familiar with from the GAR contract doesn't mean it's contract law. It just means it's specific to that contract. So you guys really need to read through all of your contracts to which you are a party to make sure you understand that contract. So let me just address just quickly, if I may, the checks. So here's the problem. Okay, you guys are all experienced agents. In the course of events, so to speak, if you have a purchase and sale agreement and an exhibit, and there's something if there is an issue that is addressed in both items, which prevails, or what the terms of which of those supersedes the other? The exhibit supersedes the purchase and sale, right? So let's say on the purchase and sale agreement on page 1, paragraph A7, earnest money. Earnest money shall be paid by, let's say you put check, X amount of dollars. but then you've negotiated to have a closing attorney hold the earnest money. Well, now we've got this, I don't have it here. Well, it has it here, and it also has it in the 510 and the 511. It says if the attorney is holding the money, it must be in the form of a wire. So therefore, regardless of what was on the purchase and sale, this is an exhibit. The exhibit supersedes, right? So it must be a wire. So what happens if the closing attorney accepts a check? What happens? Contractually, where are the parties? The buyer is now in default. The buyer put in a check because the attorney's office accepted a check. Inadvertently, on purpose, because they don't care, whatever. Now, not Andy's office.
Guess who half the time has brought me that check? The agent.
So, here's the thing. Not the broker, he said.
No, I'm not the broker.
So here's the issue. The buyer is now in default, okay? Because the seller did not agree to that, because you used that exhibit. So then I get asked all the time, well, why don't we just write a special stipulation that the attorney will accept a check?
Or scratch out on the 511 wire and just say that the check's okay.
You cannot do that. Who signs the purchase and sale agreement? Does the attorney sign the purchase and sale agreement? A buyer and a seller cannot agree to tell Andy what he can or cannot do without his signature. He doesn't agree to that. On the other hand, the Form 511, who signs that? Attorney. And the 511 is not an exhibit to the contract. It is an agreement that the attorney signs to hold the earnest money. Do the buyer and the seller sign that? No. And on that form, it says the attorney must sign it without modification or unaltered, I believe is the actual verbiage they use. So you can't special stip that out. But after the fact, because the act has already been done, a couple of things happen. You would have to, the buyer and the seller would now have to amend the contract because that it's already been done. Unless the closing attorney is going to refund them, it's just a mess. Now here's the other thing. You guys always leave this paragraph 8 blank, alternate holder. What happens if the closing attorney doesn't accept the wire? Because there are some attorneys that won't accept earnest money if it's less than a certain amount of money. Or what happens if they don't sign it within the time frame prescribed in the thing? Then what this verbiage says is there's an alternate holder that all of a sudden becomes the holder of the earnest money. You have all kinds of problems if the buyer has, or the agent, of anybody who's not here, right? If the buyer has brought a check to the closing attorney's office, the closing attorney has accepted it. The closing attorney never signs that 511. It reverts to the alternate holder. The alternate holder now sends notice to the parties, we don't have earnest money. And the buyer's like, I just put earnest money to the... Do y'all see the issues? There are a lot of issues with the GAR 510 and the 511. We did talk to Christina Chow, who is legal counsel to GAR. They are going to look at both of these forms, either for the mid-year review or for 2021. One of the things they are going to do is look at taking out wire or ACH only, along with a lot of other issues.
I have some proposals, because my office, I mean, all of your closing attorneys that want to do good business with you, you know, want to find ways to get deals closed smoothly, and we're certainly one of those. So, you know, if you present yourself in our office with a check, I mean, we've tried to find a workaround with this, especially with respect to these more recent changes. So if you come in with a check, well, a lot of folks, we try to tell you, say, look, this says you're supposed to have a wire, and you've not only violated the contract, you're sort of, you know, you're violating your own license law because you know that you're violating the contract, and nobody wants to hear that. So we'll say, look, you really need to go get an amendment to your contract. And most agents will say, okay, that's fine, but can you just go ahead and deposit the money? Like, Because I know I'm gonna be able to get an amendment, it's not gonna be a big deal. Everybody just wants this deal to close, nobody cares if it's a wire, can you just go ahead and deposit the money? And, you know, it's like, okay, well, what if they don't? Because if we deposit, I'm not just gonna hold the check, because that's not a real thing. That's earnest money purgatory. It's not a real thing to just hold the check. You either deposit it or you make them walk away with it. So we're you know, effective this year, we've sort of generated a sort of an agreement or understanding. We will hold a check. I mean, not hold. We will deposit a check with an understanding that if you're going to leave, you're either going to get an amendment to it signed, or you're going to wire the money, and it's going to be essentially a double deposit, and your buyer is not going to get that check back until both the check clears and we've received the wire. So we'll adapt if you guys want to play it that way.
And it is a license law violation. If you acknowledge the buyer's bringing a check, it is, as Andy said, a license law violation, because it's a license law violation to knowingly falsify a contract regarding the earnest money when you know it's in one form, but the document says it's in another form.
And here's another way. Tell me what you think about this. I think you could do a workaround right up front on it and still use the 510 and 511. I think if you feel like you have to use those forms, go ahead and use them, but just go ahead and attach an amendment. And I created some model language for it that just says all parties agree that a check for earnest money is permitted, and we all agree that this form supersedes the F510 and 511, and just attach an amendment along with the original contract that is right after the 510 and 511.
Why go through all that? Why not just
Wire the money. Yeah.
Because you're going
Or have the broker hold. Here's another thing to consider when having a closing attorney hold the earnest money. Now, the closing attorney can't. They have IOLTA accounts, which are trust accounts, and there's lots of regulations regarding that, and an attorney can't violate civil or criminal law. However, your brokers are also held to license law. So if I do something unacceptable with trust funds, I can lose my license, I can lose my firm's license, and there's a whole additional set of laws to which I am beholden that, again, you're not going to do anything criminal or illegal with the money, but it might go contrary to what you have, what your understanding of the contract is, or what a buyer and a seller. Now, we are moving in the right direction. Prior to this form, it used to be 83 and 84, if y'all remember that, a couple years ago. Prior to this, y'all, and in other contracts, there isn't anything that the closing attorney signs. Y'all are having your buyers giving the attorney, here Morgan, here's thousands and thousands of dollars, with no paperwork attached to that money. The closing attorney doesn't, there's nothing in the RE forms, a HUD form, unless it is specifically in there, there's not, but even if it's in there, the closing attorney doesn't sign those forms. So we're moving in the right direction. It just needs a lot of work to try and.
Well, and to your point, why is all this hullabaloo about writing a check? And you'd be surprised some of the questions and reasons I get. Well, the folks just moved to town, their bank's back in Texas, they've already moved, they can't go back to Texas and wire the money. You know, there's all these reasons why they just can't wire the money.
Yeah, I didn't mean for you, I just meant as an agent.
Yeah, you would think, why is it such a big deal? Just go wire the money.
Right.
But sometimes they just say they can't.
Or hold it with a broker.
Right. And, you know, I have some small brokerages now that they don't have trust accounts anymore. So it's just, there's gonna be a problem.
One of those things that makes Dawn stand on her head.
Yes.
So did you want to talk about the earnest money when it's tendered by a party that's not a party to the contract?
Yeah, so there is another form, this form has been in existence, it's on page 22, and this is a great form to use. It's not an exhibit to the contract, but basically, if you have a buyer who is writing a contract and somebody else is tendering the earnest money, friend, business partner, sibling, parent, whomever, that's fine. But and there's nothing that requires a signature, but as a point of practice, this is a great form to get signed. It is an acknowledgement. It is signed by the person whose bank account the money is coming from. Now, is that person on the purchase and sale agreement? No. So basically, this is just, what they've added is what I have underlined that says, guess what? If I'm the holder of the earnest money, or if Andy's the holder of the earnest money, we don't have to talk to you because you're not on the contract. But I'm the one that put in the money. That's fine, but you're not on the contract. So this is just an acknowledgement that affirms that the broker or the holder of the earnest money doesn't have to talk to that person. The other reason, so this, we really like this form. The other reason this form is really good for you guys as agents is to get this signed and get it into the hands of your lender. Because now gift funds is a completely separate thing. This isn't, it can be used for gift funds, but it's more like, hey, somebody else wrote the check, right? You'll get to a couple days outside of closing and all of a sudden you'll get a call from the lender. We can't source the earnest money. We can't use it with respect to the loan or the contract because it didn't come from the buyer's account. So you need to just go write an amendment taking out the earnest money, okay? Just go take care of that. Well, how do you think a seller is going to respond to removing earnest money from a contract prior to close? Yeah, hello, then I've got no protection should the buyer default, right? So if you, and kind of be kind to lenders, some lenders won't recognize that the earnest money is from an account that's not the buyer's until late in the game. And it causes all kinds of contractual issues, confusion, delays, and potentially confusion with the closing attorney preparing a closing statement. We have earnest money, now we don't have earnest money, we can use it, we can't use it, we have to put in additional earnest money. There's all kinds of issues. So this is another form that is good to get signed by the person whose bank account the money is coming from to get into the hands of your lender early. Because if the lender is not able to use that per the loan, it can be addressed up front and early rather than late in the game when emotions are typically a little bit higher and you're trying to close and it's going to prevent or delay a closing. All right, next form, seller's property disclosure statement. Turn to, on page 24, there's one thing they added under system, paragraph 5 under systems. They added paragraph G, are any systems or components subject to a lease or rental payment? For example, HVAC, security, so forth and so on. There can be what's called a UCC filing. There can be a third party that has a secure interest in that and would prevent the conveyance of that thing. So that's just important to know. But then the biggest changes they made, turn to page 28.
Sorry, I have a really quick question about that line. Does
Okay.
that mean like if the seller has put that new HVAC in but is making payments on it and closing is not completed, isn't that still liable to them? And what aspect would the third party have interest in that, like HVAC?
They could be renting a flat.
Well, the UCC filings typically has to do, like if you sell commercial property and there's like, let's say you're selling a restaurant, the restaurant that Bob went to, and let's say, sometimes an owner will rent the equipment, but then the owner wants to sell the property. Well, and I don't want to get too much in this because it doesn't pertain to the changes in the contract, but basically it's almost like there is the equipment company that has almost like a security interest in the equipment. So I as the equipment company, I've got a transaction with Bob. Well, now if he goes to sell his property to Morgan, basically I don't want to have to repossess the equipment out of that building, and Morgan buying this property needs to know that the equipment isn't free and clear to be conveyed.
Okay.
So my understanding is with HVACs now and some other
Water heaters,
residential.
generators. Well, I'll tell you the one that I really wish they would have specifically mentioned that's not here is propane tanks. And not so much down here maybe, but when you get pretty much north of Canton into Ball Ground and
Yes.
Pickens, and it's super common up in my
You're talking about the big ones.
Oh, yeah.
They pound the yard.
Yeah, not the one. And those, and typically they do, like Gas Incorporated and a lot of those will put memorandums of lease in the title work, but you're not gonna find that out until maybe a week before closing when we send out an owner's commitment, or maybe not even at closing at some firms. So there may be a big surprise for the buyer that, hey, there's a lease on this property, and if it's not continued by the buyer, they're gonna come yank that tank out of there. So I think that's,
So what are they doing with those HVAC? Because now that's a big thing. Reliable's huge into that now.
I
Where they,
didn't even know that myself.
oh yeah, they're leasing. So you get a piece of equipment in, exactly like you said, it's water heaters, generators, HVAC, and it's part of the property. They're not going to pull it out. They did do the individual signs it, but it's going to end up staying with the property, and that's where their money's going to come from, because they're not going to, they're not allowing it to their contract go with the homeowner when they leave and the equipment's still there. There's,
Yes.
I mean,
have y'all
I
seen
imagine-
any of that?
Trying to figure out like how
It
that
would be
falls.
considered an attachment
sure.
at that point. I mean, I imagine the company would have to sign an agreement with the, I don't know.
Do they have security deeds or something that
And I
have
don't
to
know
be
how that
paid
affects
off?
title.
Well, not
Yeah.
to do on-
I get
Because how
from
would you
a
know
title
that?
perspective, like I said, the propane people are filing, the propane people file, use, it's typically a memorandum of lease. So, I mean, I haven't seen, like anything from Reliable. We do UCC searches along with every title exam, so
Yeah.
if that's a new thing.
Yeah, but it's been going on for about a couple of years. It's a big deal. It's millions and millions of dollars that they're doing, so it's starting to become a mainstream thing.
Well, so now we know why GAR put it in, and it might be something, I haven't run into it as a broker, and it might be something just to investigate further. It doesn't sound like it's come
Yeah,
up.
if we start seeing some
too
defaults,
yeah.
then we'll start seeing them in the title work.
Yeah.
Would it have a due on sale, transfer?
I don't know, I have no idea.
It'll be something, just like you pay off a mortgage and an equity line, you'll pay off the rest of your HVAC, and it'll
So
be
they
paid
should,
off.
they should sign a contract for that.
When they get
That's,
it.
When
that's
they
what I'm
bought
trying
it.
to figure
Yeah.
out.
Yeah,
They should
they
attach
would.
that to
It'll,
this
yeah, it'll be a
contract.
security interest,
I
and
would.
it'll be another thing we have to get a payoff on.
And list it.
You guys, your buyers need to really go over this, and remember your question.
Yeah.
Another issue we just had last week is we had a buyer go, we're 2 days outside of closing, buyer went to get hazard insurance, they pulled what's called the clue report, and there'd been too many claims on the property, so I don't remember if the hazard insurance wouldn't insure it or the premium was just sky high, and the buyer wanted to terminate and wanted to know if they were outside of all contingency, wanted to know if they terminated, did they get their earnest money back or not? And my question is, well, did the seller disclose, because there's a section in here, I think it's paragraph 12,
Insurance.
Right.
did the seller disclose, have there been insurance claims or not? If there have, to me, that goes back to caveat emptor, the buyer, and you guys as agents, y'all need to be aware of this. I'm doing a video, if you guys don't know, I've got a YouTube channel where I do contract tips.
Yep.
This is my video coming out next week, because it just happened this weekend. If the seller had indicated that there had been insurance claims, to me, the burden goes back to the buyer to check with their hazard insurance prior to the end of due diligence to see what the insurance premium was. Had the seller put 0 in there, then that might, to me, would, as a broker, I would probably give the buyer their earnest money back. I can't make a blanket statement without looking at the contract, because the seller did not disclose that there had been insurance claims on that. My point to you guys as agents is, don't just take this and attach it and whatever. You need to really take a look at this leasehold, this lease, these systems being leased, the insurance, so forth and so on. One more question, then we gotta move on.
Yeah, so that was actually to the line that we were talking about. So if it's leased, the seller fills out this disclosure, because it's not required. So if they decide to fill it out but don't fill out that aspect of it, now we go to closing, and we're finding out after closing that they're gonna yank this out, or my buyer now has this payment plan situated. How does that fall into play? Is the seller liable for
The
that?
buyer needs to hire an attorney
Yeah.
and handle it that way. You're out of it.
Okay, cool, thank you.
Now I've got to text into the sales director at Reliable to see if he can answer that.
There's another issue too. What if the seller's property disclosure form is not attached to the contract? That's, again, your buyers, you as buyer's agents, And at maximum one, we have a form called a service recommendations form, and if I can read your email, I'll be more than happy to email it to all of you guys. If you're not a maximum one agent, please check with your own broker to make sure that your broker gives your consent to use this. Basically, it's a form, and it says, as a professional, I recommend all these things. And it says, buyer, I choose to have an independent home inspection done by an inspector of my choice, yes or no. I choose to have owner's title insurance, yes or no. I choose to have a survey, yes or no. I choose to have a radon test, yes or no. I choose to check for mold, yes or no. Then it has a fill in the blank. Then it has a hold harmless language, and then everybody signs it. I suggest as a broker that you guys as an independent contractor get this in the hands of your buyers so that when something comes up after the fact, like a survey and a driveway not being part of the property or something like that, you can say, you chose to not have a survey. So again, I'll be more than happy to email that to all you guys. Please run it by your brokers first. But you guys, we've got to move on. Okay. So paragraph D in the fixtures checklist, they've added, I'm going to paraphrase because we've got to move on. Basically, the GAR seller's disclosure form has check marks where a seller indicates what they're leaving with the property and what they're taking with the property. Well, basically what this new sentence says is if the seller has said, I'm going to take an item, but they actually leave it, then the buyer, if they didn't want it, they need to have it removed, and if they have it removed within 30 days, the seller is responsible for the cost of removal. For example, you got a pool table with a big old slate table. The seller loves their pool table. I'm taking it with me, I'm taking it with me, I'm taking it with me. Then they hire movers, and they find out how much it costs to move that slate pool table. They're like, well, I can buy another pool table for that. We love it so much, the buyers are going to love it too. They're going to love it. We're going to leave it. It's our housewarming gift. Buyers move in, here's this big old heavy pool table. They don't want it. Well, if they pay to have it removed, the seller is financially responsible for the cost of removal of that item as long as the buyer's had it removed in 30 days. That's what that new sentence is. And then under systems, they've added car charging station and above ground pool.
Oh, very good.
All right. Oh, Andy.
So we're gonna go ahead and skip the community association. In the interest of time, I'm guessing we don't get to do that.
Can we do that in our contract?
You guys,
We got 25 minutes to
Okay.
do, I counted roughly 45 slides. So,
okay. The community association disclosure has been reworked. How it looks. They've redone a lot of paragraphs, they've added more verbiage, so forth and so on. The general content is the same. Sellers, you agents representing sellers, your sellers have got to find out what fees are associated with the HOA and with the management company. Not only for themselves as being a member of an HOA, but for the buyer buying their property and being initiated in there, transferring, all the fees that are associated, and special assessments that have already been addressed and voted upon by the HOA. And, now this is the funky part, so we'll talk about this just a little bit. So again, I'm not going to read through all this because basically the intent is the seller needs to find out this money, disclose it on this form. If the seller does not disclose those amounts on this form, then even if it's a buyer-related fee, the seller is going to pay it at closing. It is not intended to be a penalty. It is not intended to be a punishment. The problem with a lot of the management companies is the management companies will only talk to the seller. They won't talk to the listing agent, they won't talk to the buyer, they won't talk to the buyer's agent. So it's difficult to have that fall in a buyer's due diligence to try and find out that information when they cannot get that information. That's why the cost is being put to the seller at closing if the seller doesn't get this information, because there's no other way to get it with a lot of associations. But turn to page 33, And look at, this is a new thing that they've added, and, you guys, we have to limit our conversation on this. This is definitely something to talk to in your sales meetings with your brokers and with your closing attorneys. But I just want to bring it to your attention what's here, because we've got a lot more to cover. Paragraph D3, so it must be DI3. Special assessments arising after the binding agreement date, right? When is this form being signed? Right, at offer and negotiation time, so before binding agreement date, but then it'll be part of the binding agreement. So what happens, and this is mostly for complexes, not really fee simple subdivisions, but what happens if the HOA has a meeting after we're binding, but before closing, and they talk about a special assessment that has to happen? We now have to charge, we're gonna assess all the homeowners, and there's gonna be more fees. Well, what happens for a buyer who, number one, that wasn't disclosed to me before that and I haven't purchased it yet, or number two, what if that throws me out of my financial qualification to get a loan for this property? All the other things are addressed. So
Or I could still qualify, but I just, budget-wise in my life, I just don't want to pay that.
So paragraph 3 says, but you're filling this out prior to binding, so you've got to think about that. So it says, with respect to special assessments that are only under consideration after the binding agreement date and are promptly disclosed, it's a key part, by the seller to the buyer. A, if the special assessment is adopted and due in whole or part prior to closing, the portion that's due prior to closing the seller has to pay. If the special assessment is adopted and due in whole or in part after closing, then that portion has to be paid by the buyer. Paragraph C, here's the one y'all are going to love. Notwithstanding the above, if the buyer's portion of the special assessment that is under consideration or approved is X amount of dollars or more, the buyer shall have the right but not the obligation to terminate the agreement upon notice to the seller, provided that the buyer terminates within 5 days of being notified of the above, after which the buyer's right to terminate shall be deemed waived. Things that make you go,
I can see that being
Those dates are
counterapplied.
very important for your checklist.
Well, exactly, and that dollar amount. So what are you going to fill in for that dollar amount? Well, guess what, you guys? It depends on if you're representing a buyer or a seller. If you're representing a seller, you probably want a higher dollar amount. If you're representing a buyer, you want a low dollar amount or zero. But that is just something to bring to your attention. Also, you listing agents representing sellers, there are a lot of sellers that could care less what's going on with the HOA. They just pay their check and they don't care. Your sellers getting ready to list property, they've got to pay attention. You've got to get your sellers to look at the minutes from previous meetings, find out what's being discussed, what's going on. Because there's another paragraph about special assessments that have already under consideration. In other words, they've already been brought up at a meeting. So this is interesting that it's in there. And it just depends on if the HOA has a meeting during those 30 days or 40 days or 20 days, whatever, in between that time frame. But it does have financial consequences and termination consequences for your parties.
So 2 quick practice pro tips, because this, understandably, maybe you guys noticed this too. This is usually one of the big contentious forms at closings. One of them is, this form does say in it, if the seller obtains information during the course of the contract that changes information that the seller previously disclosed, the seller shall be obligated to provide the updated information to the buyer during the course of the contract. So what often happens is, the seller will give the initial form to their agent, or they'll turn it in and they'll say, okay, the assessments is this, and the initiation, transfer, and clearance letter fees are $1,000. And then a week later, after the contract's been turned in, the seller will say, oh, you know what, I realize that the total of those fees is actually $1,500. And the seller's belief at that point is, well, now I'm off the hook because I've given the updated fees. Well, actually, no, this form does say in it that you're still liable, seller, for your penalty of having shorted the buyer on that information. You're still liable for that difference that you shorted. You have to pay for having under-disclose that information. Thank you for giving us the updated information, but that doesn't put you off the hook for having to pay for under-disclosing. So please manage expectations with your sellers that even though they've given that updated information, they still have to pay the shortfall. The other thing is, we, a few times a year, have upset sellers who went out and paid for their own letter, which then, they find out that the closing attorney also paid a letter and that they have to reimburse for that. This form in at least 2 places says that they have to pay for the letters that other people obtain, even if they pay for their own letter. Too bad, I'm sorry for that, that's just the way it works. So if you could help manage their expectations with that, that's just, and I think we've been trying to fight HOA companies in the Georgia legislature for several years. Both your lobbies and ours are fighting together to do that. So HB 410, I think it is. If we can continue to pay to our PACs to do that together, to fight the good fight to keep those clearance letter fees down. I think we're fighting towards $50. They're fighting up toward $500 if we could at least meet somewhere. So that those are not so expensive. Because I do feel bad for sellers that say, well, I couldn't get the information you wanted without paying for a damn $200 letter, and I have to get my own letter to comply with the title insurance requirements. So therein lies the problem. And that's it. We can move on.
All right. Next thing is the sale or lease of buyer's property contingency form. This is a big change to this form. Basically, if a buyer purchases a property, but they have to sell their existing property first, but the seller says, I'll go under contract with you knowing you have to sell your property first, but I want a kick-out clause in there, meaning if I get another property, I'm going to give you whatever y'all negotiate, 24, 48, 72 hours to decide, are you going to stay in contract with me, or am I going to kick you out and go with the second contract? Prior to 2020, if the seller exercised the kick out and the buyer stayed in it, at the point the buyer chose to stay in contract, all buyer contingencies were removed from the contract. No more due diligence, no more appraisal contingency, no more financing contingency. They had to go to closing. If not, they would be in default of the contract. For 2020, they've changed this form where a buyer and a seller can negotiate. If the seller's going to exercise the kick out and the buyer wants to stay in contract with them, you can negotiate what contingencies actually get removed from the contract or what stay. For example, you can negotiate, so this option would be basically the same form that it was in 2019. Or you can negotiate just the sale or lease of the contingency. Look, seller says, look, stay in contract with me, but this deal is no longer contingent upon you selling your house, but you're still going to have an appraisal contingency and a financing contingency. Or you can pick and choose among any of the contingencies that choose to stay with the contract or get kicked out. So it's definitely a little more favorable to a buyer. But in essence, it's really not that bad for a seller either, because if a second contract the seller is going to get has a loan on it, that second contract is going to have an appraisal contingency and a financing contingency. But if I'm already in contract with you and we're 20 days into it or 15 days into it, your people are already working on the financing and the appraisal. So as a seller, I don't have to start back from square one. So definitely looks more favorable to a buyer, but there are definitely some incentives for a seller to negotiate through those as well. Mm-hmm. All right. Property amendment to address concerns. Backup contingency, and I apologize, I don't have this in your form. Backup contingency exhibit. So a seller's under contract with a primary contract. They get another contract that they want to accept, so they negotiate through that, but they use the backup contingency exhibit. Okay? So, and the backup contingency exhibit references the primary contract. Everybody was getting confused because what's the binding agreement date of the backup contract? when it's binding, right? We had a pretty lengthy discussion on binding agreement date. But what is day 0 for all the time frames, the contingency time frames in the contract?
Then they're notified that they're primary.
It is when they receive written notification that they're primary, okay? When is earnest money due?
When the contract states from the binding date.
From the binding date. Now, GAR has, I love this change on the backup contingency. So now it says, time limits except the delivery deposit of earnest money shall commence on the date that the notice of termination of the primary is provided. It used to use the word binding contract. The problem is we're already binding. So GAR, there was so much confusion as to when the time frames kicked off for the contingencies. So they've made that clear on this one. This is a good change. That day 0 is when they, as Patty said, when they receive notice from the seller that we're now in primary position. But the binding agreement date was back whenever, when buyer and a seller sign and have notice of acceptance. Okay, now, amendment to address concerns with the property. I normally go into a whole long illustration so you guys get this, but in the interest of time, I won't. But I will tell you that this is an amendment like any other amendment. So generally speaking, is there a time limit on an amendment?
Unless you put one in.
Right, but without that, there's not. In 2020, GAR has added, actually they did it in June of 2019. They've added this paragraph that says, this amendment is intended to set forth the agreement of the parties relative to concerns raised by the buyer during due diligence period. If this amendment does not become effective during the due diligence period, it shall become null and void and of no longer force and effect. In essence, the due diligence, what's a due diligence period? Conceptually.
Options.
For what? Who has rights in a due diligence period? The buyer has right to do what? Terminate. Period. End of story. That's all a due diligence period is. Does the seller have any rights during a due diligence period? No. Does the seller, however, have incentive during the due diligence period to negotiate some additional items with the buyer? Absolutely. The problem is, remember we did a purchase and sale agreement? Well, now we're binding. The buyers had an inspection done and find some things that they want the seller to address. Buyer initiates an amendment to address concerns with the seller. 1, 2, 3, 4, 5 things. Seller says, Bob's still out to dinner. We'll go to Andrew. I guess I gotta move here because of the video. Okay, Andrew, I'm your buyer, you're my seller, we're under contract. I found a couple things. Hey, I don't want to terminate, but I still have that option. I have 5 things I'd like you to address. Andrew, as the seller, says, well, I'll do 1, 2, and 3. I'm not doing 4 and 5. As an agent, how do you, as the listing agent, communicate that back to the buyer's agent? Paperwork-wise, what do y'all do?
Strike through.
You either take that strike through, scratch and sniff, or you pull out a new amendment to address concerns that says seller will do 1, 2, 3, 4, send it back. In essence, we have either a counter amendment or whatever, however you want to look at it. It's an amendment now initiated by the seller to the buyer, okay? Prior to 2020, let's say we're on day 10 of our due diligence period. At this point, paperwork-wise, the seller has now either made a counter amendment or initiated a new amendment to address concerns back to the buyer, okay? We had a 10-day due diligence period. We're on day 10. 1159 comes and goes. We're after due diligence period, which is what? 12. Buyer's right to terminate, right? Mm-hmm. The buyer didn't terminate. The buyer's still in the contract. Now the buyer signs that amendment that the seller, that Andrew sent to me, and I send it back to Andrew. Prior to June 1, 2019, was the seller obligated to do those repairs?
No.
Why? Why not? What is due diligence? Buyer didn't terminate. What does that have to do with the seller? We have a fully executed amendment. The seller absolutely was obligated to do those repairs. I've got a fully executed amendment that says the seller's going to do 1, 2, and 3, right? Mm-hmm. The seller says, that's not right. I don't have any incentive now. Had I known the buyer's gonna stay in it anyway, I wouldn't have agreed to do any of it. Doesn't matter. But it was a problem because everybody thought the due diligence period had something to do with the seller. It has nothing to do with the seller. It's only a buyer's right to terminate. So now GAR has added this verbiage. So now, if the buyer doesn't send back that counter amendment before 11:59 p.m. tonight, if I send it back on day 11 in this example, now if it was binding on this one, the seller now has no obligation to perform those repairs. But prior to this paragraph, absolutely, you guys, we have a fully executed amendment that was never withdrawn by the seller prior to execution. See why that's important? It's important for you listing agents. All right. That's about it for that. Go ahead. 5 minutes. Okay. We're going to knock out these really quickly. In the listing agreement and the buyer brokerage agreement, some of those changes we've already addressed, the statute of limitations, blah, 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 cyber fraud are in there. One important thing they added in here is
The retainer fee exhibit?
the retainer fee exhibit is an exhibit, and the retainer fee used to be trust funds. In other words, if a buyer put in a retainer fee with the broker, we could not disperse it until either that buyer brokerage agreement had terminated or had closed. Now there's verbiage in there that it's no longer trust funds. As soon as we receive the retainer fee, it's for services rendered and we can disperse it now. But turn in your little handout to page 40 and look at paragraph B1. This paragraph had been in the contracts. They took it out for the past couple years and they put it back in. And it's the same paragraph we addressed a little bit more in depth in the purchase and sale agreement. What I have underlined is any agreement to terminate this agreement or any other subsequent agreement of the parties related to the property must be in writing and signed by the parties. GAR had taken that out because GAR's like, hey, we don't want our agents going under contract, signing a brokerage engagement with a buyer or a seller and then telling the buyer or seller how to terminate. So they took it out. The problem is we still unfortunately had buyers and sellers terminating, but how do we know if it was terminated or not? Because sometimes we have buyers, they stop calling you, or they text you, say, I'm done with you, or they send an email, or you get a call from another co-op agent saying, oh, whatever, you get a call from the lender, hey, I thought you were working with this buyer, I just did a loan for this buyer on this property with another agent, right? So was the brokerage agreement terminated or not terminated? We're pretty well versed on how to terminate a purchase and sale. So GAR has put this back in just so that now we have a line in the sand, so to speak, of a public person terminating the brokerage agreement. It must be in writing and it must be signed by the party, the buyer or the seller. So a text message, is that signed? No. And them just stop calling you, is that signed? No. So this is, even though GAR took it out because they didn't want that conversation coming up, it didn't prevent public people from firing y'all, so to speak. So they put it in there just so that we have something to go by. There is, just like there are termination agreements for purchase and sale agreements, there are brokerage termination agreements, a mutual and a unilateral, and those are addressed in there. For those of you guys on the video, I will attach these handouts to the link in the description of the video. All right.
While we're talking about listing agreements and she's looking for that, I don't know if it was earlier in the presentation, but there was something mentioned about a seller's agreement not to market the property on their own.
And that's what this is down. Go ahead.
Okay. Oh, here it is.
Good segue.
Yeah, I wanted to make sure that we did get to that.
Paragraph, page 41 is a brand new paragraph under marketing. It's 5E, no marketing by owner.
Okay. And maybe you want to talk about this?
No, go ahead.
Okay. Because I know that there's the general annoyance that they're just kind of doing what you do best, and they feel like they do it best because they love their house. Part of it has quite a bit to do with fair housing. You'd be surprised some of the things that they really can't say that they think they can say, particularly with the neighborhood being great for empty nesters or awesome neighborhood. very few children. Stuff like, I mean, really, stuff like that may seem rather innocuous. If you're of a certain age and you think you're marketing a neighborhood for other people of that certain age, I mean, but stuff like that violates fair housing. Close to churches, that's not good. You know, nice Christian neighborhood. I mean,
Quiet neighborhood next to funeral.
yeah.
Next to cemetery, I put that in years ago.
But yeah, so I think that's the way. Rather than you presuming to be better at marketing than they are, which you are. I mean, you can tell them, hey, I don't want you to get sideways with fair housing, so just let me handle this. That's usually the best. Maybe that's the best play.
And from a broker perspective too, so from a fair housing, there are state and federal fair housing laws, and there are license laws pertaining to fair housing. But our public people are also subject to fair housing laws because they're state and federal laws, so they can get in trouble too. I believe the other reason they added this is because we would get the calls, y'all would get the calls, you didn't do anything to sell my house. I sold it. I'm the one. They called off of my ad. They called off of my southern accent's really coming out now, isn't it? They called off my Facebook post, right? So I'm not paying you commission because I'm the one that sold the house. So I believe that's why they put that in. Now there is language in there that you can give them permission to market their house or approve of it or something, but those are the two rationales for why GAR has put that in there. Again, with these other issues we have addressed in the purchase and sale agreement, cyber fraud, limits of liability, so forth and so on, statute of limitations. Retainer fee exhibit, again, it just says that it is earned upon payment, so it's no longer considered trust money. And then just a couple of new forms. There is on page 57 a new construction change order amendment. So this is if you are writing a contract for new construction using the GAR form. This just had not been in existence. Page 59, if any of you guys are working with a move-in or move-out inspection form on a lease, they've created a short form for move-in and short form for move-out. They still have the long forms in existence. Broker to independent contractor, I don't care who holds your license, y'all are better, if you are helping a tenant or a landlord with a lease, y'all are probably better served by using that long move-in, move-out inspection form rather than the short one to avoid issues when the tenant moves out. There are some changes to the lease agreement. Again, there's not a whole lot in there. There's some clarification that they've done, and they have put in some verbiage in there. If the tenant tries to sue the landlord, there's a statute of limitations that is 1 year, and I believe that's the law. I don't know, but it's 1 year on a lease, statute of limitations on that. And then there is a new exhibit, another new exhibit, which is pool on property. You guys, this is just for leases. This is not for purchase and sale agreements. If you are working with a landlord who is leasing a property and there is a pool on the premises, you absolutely want to include this exhibit because it has all kinds of verbiage in there about who is responsible for maintaining the pool, liability, insurance, all kinds of issues regarding the pool. This is definitely something that protects landlords, but in addition, it does put a tenant who is leasing a property with a pool on there on notice of what is required of them regarding the maintenance and the liability and the safety issues regarding having that pool on the property. So again, the new forms, that new construction change order, the short move-in, move-out, and the pool on property, that's all the new forms. The new special stipulations, again, we talked about this. This had been in the conventional. They took it out, made it a special stip, and the FHA-BA. And the other thing is, this is kind of funny to me, lead-based paint, the pamphlet is an EPA pamphlet. GAR had a copyright on there. It's not copyrighted by GAR, it's copyrighted by the EPA, so they just corrected, that issue. That's about it. Andy, final thoughts?
This is the first year we actually made it by 1 o'clock. This is hardly there after.
Questions?
Y'all, it's not a question, just an
I
update,
was
so
in here.
everybody knows. My buddy over at Reliable sent back and said that new equipment can be transferred to the new buyer or bought out. I mean, if they transfer it, they have to pay. It's an ongoing fee. Or they can buy it outright, but it's gotta be in the contract somehow. And it is, there is a UCC filed on the home, so.
So that is going to come up, and probably the more techie some of these things get with some of these alarms, because as the techier the alarms get, there might be, the cost might be such that you lease it. So that's definitely something to pay attention to, both on the buy side as well as on the seller side. Any questions? What do y'all think?
Thank you.
Thank you guys so much. Andy, thank you. Appreciate it.
Yeah, I like her.
All right, you guys, go help everybody with their purchase and sale agreements, and we appreciate y'all so much. Thank you.